May it please the Court. My name is Radzivilovskiy, and I'm representing the respondent. The issue in this case is whether a school instituting a moment of silence as a way to calm the students down before basketball games somehow violates the Establishment Clause under the First Amendment. Fordham High School is having a problem with violence and at basketball games. A moment of silence before basketball games was proposed by a student to the principal, which would be introduced through the gym sound system by a student. A student complained that a moment of silence violated the Establishment Clause and sued to prevent the moment of silence at future games. She was a cheerleader at the games and was required to attend so that she could get phys ed credit. No other students were required to attend. The district court held that the moment of silence was unconstitutional, but the circuit court reversed the district court's decision because there was no evidence that there was any form of excessive government entanglement. The case was appealed to this court, which granted certiorari. The three-pronged test for whether government action violates the Establishment Clause was laid out by this court in Lemon v. Kurtzman. The statute must have a secular legislative purpose. Its principal or primary effect must neither advance nor inhibit religion. Third, the statute must not foster an excessive government entanglement with religion. None of the prongs are in any way violated. The school had a secular purpose of introducing the moment for meditation, introspection, and prayer, following a study that showed that a moment of silence calms students down and actually prevents school violence, which was a problem at the school. Our case is very similar to that of Brown v. Gilmore. The circuit judge in that case ruled that there is nothing wrong with instituting a moment of silence for secular purposes of maintaining good order and discipline, creating focus on the activities at hand, and assisting teachers in beginning the day with a period of calm. This act does not have a principal or primary effect of advancing religion because no one has to pray or even stand up. Its primary effect is providing students with a moment for quiet reflection. In fact, Nina Stein, the student who led the moment, said through the speakers that this is a moment of silence for reflection, meditation, introspection, or prayer. Or, not and. In Lee v. Wiseman, the Supreme Court ruled that the government violated the second prong of the Lemon test. That case is distinguishable from our case because there the state officials directed the performance of a formal religious exercise at a graduation ceremony by choosing a religious participant, a rabbi, to come and lead the event for short prayers. And in our case, the school didn't choose any religious figure to lead an event, but rather a student. And all requested was a moment of silence and not a prayer. Our case is also different from the Santa Fe case, where an invocation was led before football games. There, an invocation had always entailed a focused religious message. Even the term invocation, as the Supreme Court explained, inevitably means prayer. Here, we have a moment of silence, and thus, the primary effect is having a moment for quiet reflection. There is absolutely no government entanglement with religion. The school isn't in any way forcing anyone to say a prayer. There's no indirect coercion because all the students have the option of either using the moment for reflection, meditation, introspection, or prayer. A whole range of options are presented, eliminating any threats of direct or indirect coercion. Moreover, unlike in Lee, this is done before a game and not a graduation ceremony, in which attendance is much more obligatory and the prayers are undeniably meant for more than just a calming exercise. Fordham High School is not involved in choosing an official religious figure to lead a prayer, and thus there's not enough to prove that there's excessive entanglement with religion. In the Santa Fe case, the court reminds us there's a crucial difference between government speech endorsing religion and private speech endorsing religion. The fact that Nina Stein said to the students that she will be praying is a private choice, and one that wasn't made by the faculty. In Santa Fe, the court has specifically said that the cases involving state participation in a religious activity, it should consider, quote, whether an objective observer would perceive it as a state endorsement of prayer in public schools. Any objective observer in our school would not see a mere moment of silence as somehow endorsing prayer or entangling with religion. A school should be free to provide a better school environment. And if the moment of silence would be deemed unconstitutional, it would prevent effective administration. This court should affirm the decision of the circuit court, finding that there is no violation of the three-prong test.